CCE, the Center for Continuing Education, is a State Bar of California MCLE approved provider. CCE certifies that this program is approved for 1 hour of MCLE credit. CCE, the Center for Continuing Education presents The Patent Crisis and How the Courts Can Solve It, featuring an in-depth interview with Stanford Law Professor Mark A. Lemley, moderated by patent attorney Patrick Reilly. Patent law is crucial to encourage technological innovation, but as the patent system currently stands, diverse industries from pharmaceuticals to software to semiconductors are all governed by the same rules, even though they innovate very differently. The result is a crisis in the patent system, where patents calibrated to the needs of prescription drugs wreak havoc on information technologies and vice versa. According to Dan L. Burk and Mark A. Lemley in their book, The Patent Crisis and How the Courts Can Solve It, from University of Chicago Press, courts should use the tools the patent system already gives them to treat patents in different industries differently. And industry tailoring is the only way to provide an appropriate level of incentive for each industry. This and other hot topic patent and IP issues are addressed in this compelling 1-hour program. Mark A. Lemley is the William H. Newcomb Professor of Law at Stanford Law School and the Director of Stanford's LLM program in Law, Science, and Technology. Mark is a founding partner of Dury Tangri, LLP, San Francisco. Santa Cruz patent attorney Patrick Reilly is the founder of the Intellectual Property Society, IPSociety.net. His background includes over 20 years of leadership practice in high-tech sales, global account management, and intellectual property rights negotiations.
Hello and welcome to our conversation with Mark Lemley of Stanford Law School. My name is Patrick Reilly. I'm the founder of the Intellectual Property Society, and our guest today is Mark Lemley, the William H. Newcomb Professor of Law at Stanford Law School and a partner at Dury Tangri. Hi Mark, how are you?
Thanks, how are you?
Just fine. I read your book, The Patent Crisis, with great interest. Did you enjoy writing the book?
Absolutely. This has been a long time in the making. Dan and I started this project in 1998, so it's nice to have it done.
Your co-author, Dan Burk, he's at UC Irvine?
Yes, he's a professor at UC Irvine.
And how did you first meet Dan?
Dan and I have known each other for 15 years or so. We show up at a lot of the same conferences, and we've done a lot of co-authoring together. This particular book, the idea for it, I think, really started when we were at a conference in the Cayman Islands in 1998 and talking about the differences in the ways courts treated software patents and biotechnology patents. And Dan's more of a biotech specialist and I do more software stuff. And coming at it from different angles, it seemed that there was something going on. The courts weren't treating these things in precisely the same way.
A favorite part of the book to me was how you entered it and closed the book by stating you were attempting to start a conversation about these problems. Where did the conversation lead you to initially?
Well, so when Dan and I first started talking about it in 1998, our interest was primarily in the question, are the courts really treating these legal disciplines differently? Are they treating biotechnology differently than software? Does it make sense? And then as we started to work out that idea, we started to think about the broader question, right, of how the innovation system works in those different industries and how the patent system can promote or in some cases retard innovation in different industries. So it evolved from a conversation amongst ourselves about whether the courts were treating different parties differently to a broader conversation about how the law ought to respond to differences in innovation.
Can you distinguish, or do you distinguish further within information technology?
Absolutely. And so one of the difficulties in sort of putting the book together is I think it's pretty clear that there are some gross differences between the biomedical industry on the one hand and the information technology industries on the other hand. But I also think there are a bunch of differences within those larger groups. Biotechnology in the biologics sense has a different set of interests and needs than small molecule chemistry, for example. And on the IT side, I think the telecommunications industry has a different structure than the semiconductor industry, and in turn a different set of needs than computer software or internet innovation. And so one of the difficulties, both conceptually for us in thinking about the book, but then also for the lawmakers in how to set policy, is that it's not easy to just say, well, all right, we'll have a biotech law and we'll have a software law, and they'll be different. There are going to be overlaps, there are going to be differences, and this is innovation. There are going to be changes over time in the industries and the things that are important. If we'd written this book 140 years ago, we'd have been talking about the special rules and situations of the railroad industry. Because 140 years ago, the railroad industry presented problems that were very different than farm implements or normal agricultural tools. But, you know, that might or might not be true today. It's just not so important.
You reminded me of the Supreme Court's recent decision just a week or two ago that was announced on the Bilski matter, in which the majority opinion stated that one of the reasons to keep the patent system more open was for advanced medical diagnostics. Now, there was a case where the courts were, although not giving a lot of guidance, but were specifically citing just one area of technology that needed special consideration.
I think that's right, and that's particularly interesting in the Bilski case because I think a number of the cases they are likely to get involve medical diagnostics. They had two cases pending before them at the same time, the Biogen versus Klassen case and the Prometheus versus Mayo case, that involved medical diagnostics, at least in part, and they sent them back to the Federal Circuit to figure out what to do about it. But I think the court's concern, at least the concern that Justice Kennedy expressed, mostly for 5 members of the court, was that we not set an artificial limit and say this kind of thing is categorically outside the scope of patentable subject matter, because science changes, technology changes, and the sorts of things we think are patentable now might not be the important things. They may be the railroads of a past century, and we need to think about innovation in areas we haven't anticipated yet.
In your discussion in the book regarding the advantages of the judiciary handling this problem versus the legislative branches, you in particular mentioned the trade-related intellectual property aspects that are related to international treaties on intellectual property. Could you speak a little bit about that?
Yeah, so I mean, our basic idea, in the first half of the book, we talk about the differences between the different industries in how they approach innovation, but also how they experience the patent system. And I think it's no accident that the fight over patent reform almost always ends up pitting information technology companies on one side, biomedical companies on the other side. And so the sort of first order thing you might do if you were a congressman is you might say, well, all right, we got to do what we do in the copyright world, for example. We need a different rule for IT patents. We need a different rule for pharmaceutical patents. That runs into a number of problems, which we talk about in the book, but the first legal problem is whether it's even permissible to do. We've entered into treaty obligations that require us in Article 27(1) of TRIPS to make patents available without discrimination by area of technology. Now, I don't think that's an absolute bar in practice, for the simple reason that lots of other countries seem to have no problem excluding certain areas of technology and claiming compliance with TRIPS. You can't get a pure software patent in Europe, for example. You can't get a business method patent pretty much anywhere except the United States. So there's clearly some flexibility in defining what is an area of technology within the scope of the treaty, but it's at least a constraint. I don't think the United States could say, we don't think patents should be available for X field, and we're just eliminating them for that field.
I really enjoyed your term deliberate modulation that you can look to the courts. Could you give some examples of where you've recently seen deliberate modulation that makes sense?
Sure. One example to me is the Supreme Court's decision in eBay. So we had a bright line rule in the Federal Circuit that said if you win your patent suit, you get an injunction. And that traditionally was how we thought of patents. They're property interests. They're protected by a property rule, an injunction. But what the Supreme Court said in eBay was not well, you should have injunctions in these cases and not in these other cases, or injunctions in these industries and not in these other industries. Congress could have done that, but they didn't. But instead, we want you to think about the equities of each individual case. Here's a 4-factor test that you apply in each case. And the benefit of something like that is it's a neutral rule. You don't have to write it anew when you get a new technology. Nanotechnology comes along and now we need a rule for injunctions in nanotechnology cases. Bioinformatics comes along and we need a rule for injunctions in bioinformatics cases. We've got a rule. It's a 4-factor test. But it's a rule that works very differently on the ground in different industries. Because a lot of the problems that the information technology folks experience with the patent system, the rise of patent trolls, the multiplicity of lawsuits on small components that go into a much larger product, aren't problems that you see in the pharmaceutical industry. And so courts can use those facts to take account of the differences in the industries and end up, as a practical matter, pretty much always granting injunctive relief in the pharmaceutical industry and being a little more hesitant to grant injunctive relief in the information technology area.
What are the various theories of patent law that informed your analysis of policy tools?
Well, so one of the interesting things from a legal scholar's perspective about patent law is that people can't really seem to agree on why it is we have the rules we have. In the one sense, we all agree. We're doing this for utilitarian reasons, right? We don't grant patents because we think there's some sort of moral entitlement or social justice. We grant patents because we want to encourage innovation. But we've got very different theories about how patents might encourage innovation, and ranging on the one hand from Ed Kitch's prospect theory that says patents are like mining claims. We should grant a broad patent to an area of potential technology to one person, and then that person will have an incentive to go dig and see what's in there. To Rob Murgis and Dick Nelson's theory that focuses on cumulative innovation, the importance not just of having one company build everything, but having a bunch of different participants build on the work of each other, sort of creating new iterations of technology. And then we've got what I think of as the negative theories of patent law. That is not so much theories of why we protect patents as why we might hesitate to protect patents. Carl Shapiro talks about the problem of the patent thicket, where so many different patents overlap and intertwine with each other that it becomes virtually impossible to go out and get licenses to all the patents you would need to operate in an industry. Heller and Eisenberg talk about the patent anti-commons, in which even if the patents don't themselves overlap, I've got to get rights from so many different parties to different components that it becomes virtually impossible to build a product like a gene chip for analysis that might require you to go out and get licenses to 2,000 different gene patents. So all of these different theories are kind of running around, and one of the things that Dan and I figured out was these people are all looking at different pieces of the elephant, to use the old metaphor, right? They've all got an idea that's right about the patent system, but it's not the only right idea about the patent system, right? They're thinking about one particular type of innovation, one particular type of situation in developing their theory, and it's not, as a result, a grand theory of everything. And at that point, the typical academic move is, well, all right, I've got a grand theory of everything. I'll tell you what explains all of this and unifies this. And our view is there isn't a grand theory of everything, and there shouldn't be a grand theory of everything. The reason we've got different theories explaining different parts of the patent system is the system works differently depending on what industry you're in, what your invention looks like, and what your business model looks like.
Which I think is especially frustrating for technologists, because technologists are driven to simplify, but the law by its nature complicates. It forces people to consider outlying situations and historical legacy issues.
I think that's right. Yeah, so certainly the law is precedent-based, right? And so we develop these rules kind of by a process of accretion, and occasionally we end up with rules that just don't make sense because they made sense 100 years ago. One of the differences to me between common law development and development through congressional action is once you pass a statute, it's on the books until you go back and repeal it. And so if you pass a law 25 years ago that made sense then but doesn't make sense now, or made sense for the industry we were thinking about but doesn't make any sense for this new industry, tough luck. Right? You're stuck with it unless you can persuade a majority of Congress to repeal it. The judicial common law development approach has the advantage of flexibility, the advantage of having judges be able to look at a situation and say, yeah, that rule made sense in that context, but this is a different factual context and we don't think it makes sense. It's a slow process. It doesn't give us the happy result of getting it right all at once. And it's going to be always a little behind the times, but it is a process, I think, that's capable of fixing itself.
Your book distinguishes between well-established policy levers available to the courts and new policy levels available to the courts. Would you mind first discussing patent validation and patent acquisition levers that are available?
Sure. Yeah. So let me, say a little bit about the distinction. Part of what we hope to do in the book by talking about existing policy levers is persuade people that we're not arguing for judicial activism, right? We're not arguing that courts ought to go out and create a bunch of new rules that undermine the rules Congress has established. And so one of the things we wanted to demonstrate was we've already got a bunch of rules in the legal system today that give courts the flexibility to do this kind of industry-specific tailoring. And on the patent validity side, those rules could be anything from principles that involve obviousness, right? So in the KSR case, the Supreme Court says, for obviousness, we really care about what the person of ordinary skill in the art would think and do in this industry. It's not we don't want to limit obviousness just to things in the paper record, just to the documents. We want to know what people of skill in this particular field would think to do, what they'd be motivated to do. And that in itself, I think, paves the way for technology-specific application of the obviousness doctrine. Because in some industries, people are going to be more creative than they are in other industries. In some industries, they're going to have particular market pressures that are pushing them to look for new solutions and that sort of thing. And so I think the obviousness doctrine, which is itself originally a judicial creation. There was no obviousness doctrine in the original patent statutes.
I did not know that.
Yep. It then got sort of adopted into law in the 1952 Act, codifying essentially judicial precedent. That doctrine, I think, has the flexibility to be applied differently in different industries, not by saying explicitly, we want a higher bar in this industry than in this other industry, but by recognizing that people of skill in the art are going to vary from industry to industry. Then you could so that's already in the law. And then one of the things we suggest you might be able to do with respect to patent acquisition is you might want to think about as a secondary consideration or an economic test for non-obviousness, how uncertain the invention was, but also how much it cost. Right? So one of the difficulties that you find in the biomedical area is not so much that it's really hard to come up with new chemicals, it's that it's really expensive and time-consuming to test them and figure out which ones matter. And so we might want to grant rewards for new chemicals even if the real work was not in the